Assalamualaikum and salam sejahtera. We begin with our headline case of Rasiah Munusamy. We, the Group 4, will present for this case shortly. My name is Ajmal Najma binti Bandah 264043 with my other group members Dalilah Zainol Abidin 264505, Adibah Shuhaida binti Abdul Hisham 264790, Hematharshini Kumaran 264671. So I'm right here with my colleague, Miss Dalilah Zainol Abidin, to present on our part. Please bear with us in the next session. Moving on to the facts of the case, the complainant in this case had made a report to the police and alleged that his wife had been taken away from him for illicit intercourse and that she was being kept in a hotel in Penang for 3 days. In the first information report, it was stated that the wife was taken away to Penang without his knowledge, with the intent that the wife may have illicit intercourse with the man. The complainant believed that the man has concealed and detained his wife and they are expected to stay in Penang for 3 days. The complainant said police helped to obtain a warrant and charged him via Section 493 and Section 498 of the Penal Code. He also stated that he believed that his wife has already committed adultery with the said man. Upon the complaint made, the magistrate on the same day had issued a warrant based upon the first information report received by her.
Thank you, Ms. Ajmal, for the brief explanation just now. I'm Dalilah Zainol Abidin. So moving on to the legal principles, there are a few legal principles that have been analysed in this case. So this case highlights the principle of mandatory requirement that need to be adhered by the magistrate after taking cognizance of offence. So the procedure that need to be followed by the court is the examination of complainant that falls under Section 133 of CPC. Also, the court lays out the mandatory requirement that need to be taken, which the magistrate shall examine the complainant upon oath and reduce the substance to writing, which shall be signed by the complainant and the magistrate. Also, the court applied the reversionary jurisdiction in accordance with Section 323 subsection 1 to call and to examine the irregularity of procedure that involve a complainant to the magistrate that falls under Section 132 of CPC regarding the complaint made by husband in relation to offence under Section 498 of Penal Code. In this case, the magistrate failed to follow the compulsory requirement in examining the complainant. So it should be noted that the object of examination is important because it serves as to acquire the facts constituting the offence, to remedy or to clarify an ambiguous matter, and to help the magistrate in deciding whether there are grounds for investigation to proceed with the case. So this is because the judge stated that the examination is just a plenary inquiry, not an investigation to define case. So the person against whom the complaint is made is not the accused. Therefore, the magistrate shall not convert the inquiry into a trial as referred to Teo Chong Si and Nan. On the other hand, the court further rely on Sheikh Chan and Muhammad Hanif to explain on the side of a person whom the complaint is made, which is not the party to proceeding because he is not yet the accused person. Thus, he has no right to be represented. Nonetheless, he has the right to attend the proceeding as any other member of public, despite he is not the party. Hence, the magistrate can examine or question him as per Janilal Mandal and Chanderdeo Prasad. To recall, the mandatory requirement must be met in order for the magistrate to determine the veracity of the complaint and whether a process should be issued. However, the magistrate was only called the complainant to attest the oath, which was inadequate to proceed with the order. Therefore, the order for issuing the warrant of arrest made by magistrate is void on the ground that it was made without jurisdiction. This is because magistrate could not begin to hear the case just because the complainant has testified upon the oath, but he has not yet to be examined. Therefore, the erring magistrate for not complying this requirement has impugned the order of warrant of arrest made by magistrate. Also, the court highlights the power of magistrate. So the court provide the Section 134 of CPC, which must be read together with Section 133 of CPC. The magistrate may postpone the issue of process to allow him to conduct inquiries himself if there is reason to doubt of the truth of the complaint. And the matter that needs to be taken into consideration in certifying the truth of the complaint is whether there is sufficient ground for proceeding instead of the conviction. If the magistrate found that there is no sufficient ground for proceeding, the magistrate may dismiss the complaint and record his reason in accordance with Section 135 of CPC. However, if the magistrate satisfied that there is sufficient ground, the court has the power to issue the summon and warrant. Therefore, it can be seen the importance of Section 133 of CPC in this proceeding as it gives effect to other provisions as well in taking a next step to proceed with proceeding before a magistrate court. Moving on to my colleague, Ms. Adibah and Ms. Hema will be covering the health and analysis of the case for the next session.
Thank you, Dalilah, for a very good and great session just now. Now I will proceed with my friend Hema to continue the next session, which is the court held and the analysis of the case. The court held in this case is that the magistrate must examine the complaint made by the oath and reduce their examination into writing by virtue of section 123 of the CPC. There is a conflict of legal powers in issuing the warrant. In this present case, the magistrate has issued the warrant to arrest the other party, which has yet to be accused person, on the same day that the complaint was lodged by the complainant, and the court had overruled the magistrate judgment by reason that the magistrate has failed to follow the requirements specified. And in accordance with section 323 of the CPC, it provides that the power to call for record of the subordinate courts, where a judge may request and review the record of any proceeding before a subordinate criminal court for the purpose of ascertaining the correctness, legality or sentence or even order passed, as well as the regularity of the subordinate court's procedure. Next, the court's view that the complaint made by the complainant did not follow the required and mandatory procedure. The magistrate did not do the necessary steps before the magistrate issued the warrant to arrest the person specified in the first information report. Hence, the magistrate in this case has failed to follow the requirement pursuant to section 133 of the CPC. Also, the complaint lodged by the complainant must be examined thoroughly by the magistrate, as the complaint might plainly be a hearsay which could not be used to issue a warrant. In this case, the complainant had no knowledge upon the wife's illicit intercourse with the said man, and thus it was plainly a hearsay. The court has examined the complaint made by the complainant, stating that I believe he has concealed and detained her in hotel in Penang, and they are expected to stay in Penang for 3 days, and also I believe my wife has already committed adultery with him. These complaints that have the elements of the allegation has been examined by the court, and the court asserted that these complaints were only the basis of his belief only. Thus, his evidence cannot be admissible on the ground that it was merely hearsay. Therefore, the court found that the complainant's complaint as a whole defective. After a careful examination has been made in regard to the evidence to prove that the essential elements of the offence under section 498 of the Penal Code, despite the certificate of the marriage being referred to the complaint. As a result, the absence of the admissible evidence and the essential elements of the section 498 of the Penal Code cannot be obtained, which caused the prima facie of the case could not be established. And on top of that, the court found the other ground on dismissing the complaint, as the complainant is beyond the remedy. As when he lodged the complaint with the time has passed, the fact that the person whom the complainant is made is not likely to abscond, and therefore it is reasonable for the police to investigate as aligned with section 108 subsection 2 of the CPC that requires the public prosecutor to investigate on this matter. Furthermore, the court made its decision that a person who is not a party to proceeding and not an accused person has no right to be presented to the court. However, a great caution must be exercised to avoid turning the investigation into a trial. Following that, the court stated simply calling the complainant to the oath, the complaint is insufficient as there is no ground and is following up with unrecorded and unsworn interview. And last but not least, the court in this opinion of revoking the issue of the warrant made by the magistrate has not been issued but yet executed to be cancelled with immediate effect as it was made without jurisdiction. Now I will pass to my friend Hema to continue with the next session.
Thank you, Adibah. A very good morning to my beloved lecturer, Dr. Aida, and my fellow classmates. My name is Hematharshini Kumaran, matrix number 264671. Today, I'm here to present the analysis of the case of Rasiah Munusamy. This case has successfully provided the basic principles of laws that arise in the carrying out the legal proceedings, especially in the initiation proceedings in the court against the complaint received by the magistrate. Pursuant to Section 2 of the Criminal Procedure Code, any allegation made orally or in writing to a magistrate is defined as a complaint. Next, according to Section 128 of the Criminal Procedure Code, a magistrate may take account of an offence upon receiving a complaint as defined by the Code, upon his knowledge or skepticism that an offence has been committed. The case of Razak versus Public Prosecutor held that a magistrate may consider an offence under Section 218 Clause 1, Clause A of the Criminal Procedure Code after receiving a complaint as described by the Code. In analysing this case, the complaint was lodged under oath by an officer authorised by Suruhanjaya Pengangkutan Awam Darat, and he also sought summons at the same time. Therefore, the magistrate began to process the summons, believing that he had adequate grounds to do so. However, in the instant case, Judge Edgar Joseph revealed that the complainant's complaint was filed under sections 132 and 133I of the CPC, which indicated that no court shall take notice of an offence under section 498 of the Penal Code unless the woman's husband files a complaint, which in this the complainant was the husband. When we follow the facts of the case, the husband asserted his wife has already committed adultery with him in the first information report of the complainant. In relation to section 133 of the CPC, the magistrate must decide first whether there is a sufficient grounds to initiate the proceedings and also to issue the warrant of arrest upon the person filed in the complaint. When we analyze the complainant's complaint, we should analyze it thoroughly by investigating before a warrant of arrest is issued, because in section 133 of the code, it requires that when a magistrate receives a complaint, he shall examine it by setting a date to examine the complaint and serve it with a written notice to the public prosecutor. Anyhow, the condition of necessary for initiation of proceedings does not fulfill in this case, because the court held that when the magistrate receives a complaint, it shall evaluate the cause of complaint. As established in Tan Ho Wat versus Public Prosecutor, the complaint must be interrogated when the complainant informed him or when the police report has been filed. Hence, this shows that it is important for the magistrate to examine the complainant under the oath to ensure that the complaint made by the complainant is true and the content of the complaint did not contain any baseless allegation. Nevertheless, to analyze further in this case, the magistrate promptly issued a warrant solely based on the weight of the complainant's complaint and the first information report. Hence, it is unfair for the other party because there is no reasonable grounds to initiate the proceedings against him. To relate with this case, it can be seen in the case of General Mandal versus Chandradev Prasad. The court stated that extreme caution must be exercised to avoid turning the investigation into a trial before a true trial takes place. This is because the public still perceive that the role of judicial system in this country is act as a safeguard to the public interest, and in those positions to protect the misuse their powers. But if magistrate do acts like impacting the entire society in this country, thus it is wrong for the magistrate to issue the warrant without taking into account the complainant's first information report, whether it is true or not. Furthermore, the following up, the complainant with an unrecorded and unsworn interview will assist the magistrate in determining the truth of the complaint. When interpreting this rule, in the instant case, the magistrate's action had amounted to a direct mischievous act in dealing with the malicious complaints involving the harassment of a person, where one individual's action impacted the entire public's time, reputation, and also waste of money and court time. As a result, it is well established that arrest warrant issued in this case is void and made without justification because the complainant filed the complaint with the intention of adducing worthless evidence that will be clearly hearsay. Moreover, in this case, the complainant made his testimony without personal knowledge and also conclusive evidence, which is highly important in this allegation. The basis of the complainant's belief was false in this case. As for the court decision, the present court made an impartial and neutral judgment by upholding the person whom the complaint was against. The judge has taken the issues regard in this case by scrutinizing thoroughly the evidence and truthfulness of the complaint. This eventually will reflect the competency of the court in making a prudent judgment without being partial to only one side. Thank you. I would like to pass the floor to Najma.
Moving on to the conclusion in this case, in conclusion, it can be seen that the complainant had no personal knowledge and that the evidence is a hearsay evidence. The marriage certificate, which has been referred to in its complaint with its number and date quoted, does not appear to have been produced for inspection by the magistrate. The court quashed the order to authorize the issue of the warrant and directed that the warrant itself, if issued but has not been executed, should be recalled and cancelled. Further, if the magistrate conducted the examinations of the complainant in pursuant with the requirement of Section 133, subsection I, may conclude that he has reason to doubt the truth of the complaint, in which case he may postpone the issue of the process. The magistrate also finds no sufficient ground for proceeding in which he will dismiss the complaint, but taking care to record his reasons for doing so by virtue of Section 135, subsection I and subsection 2. If the magistrate dealt with the case in a manner pursuant to Section 133, subsection I, and is satisfied that a prima facie case is established, he is not bound to issue a warrant, for clearly he has a discretion, if he thinks fit, to issue a summons for causing the accused to appear in court instead of a warrant by virtue of Section 136, subsection 2. That is all. From us, the Group 4, Assalamualaikum and Salam Sejahtera.